my name is Bridget and I'm an attorney. I work in the area of wills, trusts, and estate planning and elder law. But today I want to talk a little bit about guardianships. I had a previous video blog that sort of introduced guardianships, about what they are and who is a subject of a guardianship. And just briefly, they're processes through court where adults are trying to take the care and custody of minor children. Today I want to talk a little bit about who are the people that are typically chosen to be a guardian. If you know someone who is pursuing a guardianship, or you know a child that for whatever reason is in need of care of their financial affairs or their physical well-being, essentially anybody can apply or petition the court to become a guardian. Typically, we find that it's, step-parents, grandparents, brothers, sisters, related individuals to that child. But sometimes concerned friends will seek a guardianship and the courts consider them. The goal for the court at the end of the day in a guardianship is to find someone who is acting in the best interest of that minor. And you may have put a will together if you're a parent of children, or you may have done a trust. But in your will you would have nominated people to take over the care of your minor children. And that's very common. In fact, a will is kind of one of the main vehicle in which parents can nominate others if they're not able to care for their children, to have others do it. So oftentimes a guardian can be someone that a parent has nominated. If a child is over age 14, a minor can also identify an adult in which they would like to have their care given. So it's a broad range of people who could be guardians, and the court really has an attitude of seeking all possible people who would be the best fit for the care and needs of the child that they're trying to find a guardianship for. The court looks at every person who applies or petitions as for a guardianship as an informant for the court on, what the best placement is. Sometimes that can make these guardianships hairy because you might have competing interests of people who want to be the guardians for a minor child. And in often cases, if that parent has left a nomination or a written nomination through a will or another device nominating a person they want to be the guardian, that may be the thing that tips the scales in those situations. But for the most part, who can be a guardian is a very broad spectrum. In fact, in some cases with a guardianship of the estate, in other words, the minor's financial affairs, even a professional fiduciary can be the guardian in that role. Once a guardian is established, how long does it last is a question I hear often. Well, it lasts until the minor's 18th birthday, mostly. Once the minor turns 18, that guardianship is terminated. It sometimes is terminated earlier in cases in which children are with a guardian because their parents weren't capable of taking care of them, and the parents then become capable, and the guardianship can be terminated. A minor could seek to get emancipated, and in that situation a guardianship would be terminated, and in some cases minors get married, and that terminates a guardianship. So those are some more facts regarding guardians and who those people can be, so that children don't end up with Jim Carrey's character on the series of unfortunate events. But if you have any questions or seeking a guardianship, it's really important that you consult with an attorney who practices in this area of law and has an understanding of them, because it's a very long and involved process and can be very difficult. Thank you.